When you have a child with special needs, one of the biggest questions you may have is how to provide for them financially after you are gone. You may plan to have money through your will, life insurance, retirement accounts, or assets. A grandparent or another family member may also want to leave your child an inheritance. Before making those decisions, it is important to understand how receiving money directly could affect benefits such as SSI or Medicaid. A special needs trust gives families a way to set aside money for loved ones with special needs while helping protect access to certain government benefits. Instead of leaving the money directly to your child, the assets are placed into the trust and managed by the trustee. The trustee is responsible for following the terms of the trust and deciding how the money should be used for your child. This matters because SSI and Medicaid have financial eligibility requirements. An inheritance or other assets received directly by your child could affect whether they continue to qualify for certain benefits. Parents also need to look beyond what is written in a will. Life insurance policies and retirement accounts usually have their own beneficiary designations. Even if your estate plan is updated, naming your child directly as a beneficiary on one of the accounts could create financial issues later. Grandparents and other relatives should be included in the planning too. A grandparent may want to leave your child money because they care about their future. The way the inheritance is left matters, specifically when your child receives SSI, Medicaid, or other needs-based benefits. Another decision families need to make is who will manage the trust. The person or organization serving as trustee will have an important role in your child's future. You may want to think carefully about who understands your child's needs, who will manage the money responsibly, and who will follow the requirements of the trust. The trust funds may be used for certain expenses and additional needs, depending on how the trust is written and your child's circumstances. This may include things such as education, transportation, recreation, personal expenses, and other costs. How the money is distributed matters, which is another reason families should have legal guidance when creating and managing a special needs trust. Parents often wonder when they should start planning. You don't have to wait until your child turns 18 or until you are older. Starting earlier gives your family time to receive your estate plan, beneficiary designations, future expenses, and the people you want involved in managing your child's financial future. Planning now also helps answer some of the harder questions. Who will manage the money after you are gone? How will your child's future expenses be handled? Where will an inheritance go? Will the plan work alongside the government benefits your child relies on? At Clenney Palmer, we are offering 5 free special needs trust consultations for families who want to start answering these questions. During your consultation, we can talk through your family situation, the benefits your loved one receives or may receive, the assets you plan to leave behind, your beneficiary designations, and whether a special needs trust fits into your estate plan. Only a few consultation spots are available. Request your free special needs trust consultation with Clenney and Palmer today.